Hello, everyone. We're here at Georgetown, and today we're going to be talking about the lost history of reproductive rights with an extraordinarily distinguished panel. My name is Victoria Nourse. I am the Whitworth Professor of Law, and I run an institute on Congress. Now, you might ask, well, what does Congress have to do with this? Well, we're going to learn about the relationship between courts and legislation today, in part. And we have some very distinguished guests, including one of Georgetown's faculty's own, Brad Snyder, who is going to introduce the panel for me today. He is a Guggenheim winner, and he is the author of a new book on Felix Frankfurter, who will play a role in today's discussion of the history of reproductive rights. So over to Brad to introduce the panel.
Hi, thanks, Vic. It's great to be here. What an amazing dream team of panelists we have, both in person and online. As Victoria said, she's the Ralph V. Whitworth Professor of Law. Her 2008 book, which everybody should now go online and buy, In Reckless Hands, recovered the lost history of Skinner v. Oklahoma. Today happens to be the 80th anniversary of the court's decision in Skinner v. Oklahoma, and it has a lot of relevance to the current debates on reproductive rights. I would also highly recommend Victoria's 2009 California Law Review article, Tale of Two Lochner's, as sort of a bookend to her book, In Reckless Hands. Has really helped me, both as a young faculty member and just over time in reading her book and reading her law review article, think about these issues. After Victoria, we have John Barrett, who's a Cardozo Professor of Law at St. John's University. He's a world-renowned expert on Justice Robert H. Jackson. He's the Elizabeth Lena Fellow and Director of the Robert H. Jackson Center, which is a co-sponsor of this event. He's an author of forthcoming books on Nuremberg and a biography of Justice Jackson, and he's the creator of the Jackson List, which gives me great joy. And if you want to subscribe to the Jackson List, you should email Professor Barrett. After Professor Barrett, we have Michelle Goodwin, who's the Chancellor's Professor at the University of California, Irvine, and founding director of the Center of Biotechnology and Global Health Policy. She's the author of the 2020 book, Policing the Womb, Invisible Women in the Criminalization of Motherhood, and she's host of the podcast On the Issues. Lastly, but certainly not least, is Melissa Murray. She's the Frederick I. and Grace Stokes Professor of Law at New York University, and she's the faculty director of the Birnbaum Women's Leadership Network, and she's the co-host of the world-famous podcast, Strict Scrutiny. Melissa is an expert on family law, constitutional law, and reproductive rights, and the author of the 2022 William and Mary Law Review article, Abortion, Sterilization, and the Universe of Reproductive Rights. We could not have a better group of scholars today talking about all of these issues and about how Skinner relates to the current debates on reproductive rights. I'm just honored to be here, and I'm going to sit back and let the panelists do their thing. Thanks.
Thank you, Brad, for that introduction. I think we're going to talk each for about 15 minutes, so we'll have time for questions, both hopefully maybe from the virtual audience as well as the real audience, because we understand there are a lot of virtual attendees. And I'm going to start off by situating this in the early 20th century. Recently, I wrote a op-ed in Slate in which I invoked Saturday Night Live in terms of its critique of the Dobbs opinion, which was leaked. And I did that because I'm an expert in methodology. Aside from writing this book many years ago, I study how the court decides its cases. And in that work, I have become a critic of an approach that is sometimes called originalism, at least one version of originalism, because there are many of them, that says that we should go back to the times in which the 14th Amendment was ratified, 1868, 1870, or 1787. And so one of the reasons I wanted to put this panel together is because we are going to talk about something that's lost in that, which is the greatest generation, the 20th century. And the greatest generation's struggles are things that I believe are important to understanding our Constitution and how our Constitution has developed and what we can learn from constitutional law in the 20th century will have, I believe, an important impact on how you address questions involving abortion, and we're going to hear from two leading scholars, Professor Murray and Professor Goodwin, on how this will impact more modern cases. So let's go back in time. We're going to go back to 1942, and we're going to talk about a case which was an 8-year fight by prisoners inside an Oklahoma prison, started during the Depression and drought and ending in World War. It's a story that I like to say marries Shawshank Redemption, because the prisoners helped bring their own case, and To Kill a Mockingbird, with a lawyer who's just been working out in Nowheresville, Oklahoma, and decides to take their case throughout the Oklahoma courts, pro bono, as they say in the law, for free. Now, this case really can't be understood in terms of its difficulty and why it seemed impossible that it would get to the court, aside from the fact there's no right to counsel for these lawyers, right? They get a volunteer. Because the law was against them. Why was the law against them? Because the Supreme Court had ruled earlier in an infamous case called Buck versus Bell that sterilization was perfectly appropriate. And in Oklahoma, in Skinner, the governor and the legislature had said, oh, we're going to sterilize the prisoners inside this prison. And the law was deeply against them. Why? Because of Buck. So let me take a few minutes to talk about Buck. It is a far more well-known case. There have been documentaries about it. I'll talk about Buck. I'll then move on to Skinner, and then finally come to a conclusion about the differences between male reproductive rights and female reproductive rights in 1942. So we're going to have to go back in time a little bit to the heyday of eugenics in the 1920s. In that heyday, there were many ideas about what to do with the so-called unfit. That category was amorphous and could include all sorts of what we would think of as stereotypes today in terms of race, disability, ethnicity. And you have to understand that race was quite different at the time. So the term race could include women, it could include, at the time, the greatest criminals were considered Irish, the Irish were considered Black. So different ideas of race at the time were percolating. And eugenicists favored immigration reform. That might sound familiar. In any event, during this heyday, a majority of states passed sterilization laws. And they did this on the theory that this would rid folks of the unfit. But at the time, there were questions about their constitutionality. And many state courts held that, this was cruel and unusual punishment. There was something constitutionally wrong with them. So there was a lot of legal uncertainty. And finally, in kind of a made-up case that was intended for the court, a Virginia doctor and folks decided to bring Carrie Buck's case to prove that it was constitutional. And infamously, Justice Holmes, although known as a progressive, ruled that sterilization was perfectly appropriate, and he coined some of the most infamous words ever out of his mouth. 3 generations of imbeciles are enough, he wrote in the opinion, approving sterilization for Carrie Buck. So this was the first reproductive rights decision for women in the 20th century, and it basically said, you are at the mercy of the state. If it's for health, welfare, we can determine that. What's even sadder about Carrie's case is that we now know, because books have been written about it, that her child was not unfit, was not feeble-minded, which was the term of the day. We also know that she was raped by an uncle, and that's why she was sent off to the asylum. So it's a deeply, deeply offensive case. It has never, however, been overruled. So by the time we get to my prisoner's case, you can see that the law is against them. The law says the state may, in fact, determine your procreative rights. Those rights are subject to state power. So as we're thinking about this, we also have to think about what happens in the 1930s. Sterilization was kind of a hobby for some people. It was also promoted by award-winning geneticists who thought it was a grand idea, and by immigration reformers, and by great institutions like the Carnegie Institute and many other fine groups. Why? Because it was supposed to rid society of bad genetics. This seemed at the time fully appropriate. After all, they had been experimenting with genetics and fruit in California for decades at the time. What's good for fruit? Well, maybe that's good for America. And so what happened during the Depression was an intensification of negative eugenics being let's sterilize individuals or address their procreative rights for people because we'll save money. And this is what happened in Oklahoma. There was an insistent push during drought and dust where they were bombing the clouds and everyone was suffering greatly to try to rid the asylums of those who were considered unfit. And remember that that term was quite amorphous. Carrie Buck was unfit because she had been the victim of a rape. The people who ended up in asylums of these days were generally white in Oklahoma because other classes of individuals, say Native Americans who were predominant or blacks, were not even considered. They didn't even build asylums that would allow for the care of black persons or Native Americans at the time. But for white persons at the time, the question was, were you unfit for various reasons? And those various reasons were quite amorphous. Now, I want to talk a little bit about eugenics because I think the term is full of contradiction. And it was full of contradiction at the time Skinner versus Oklahoma was being litigated. So there was something called negative eugenics, and negative eugenics was about ridding the society of the bad genes. And America was a leader in that. Most of the states had sterilization laws that applied to the feeble-minded, the unfit, however they described it. And we actually sent those laws to Hitler. And this has been well documented by other authors, by the way. Jim Whitman has written a great book about this. But eugenics itself had two different faces in America. And this is why people were not particularly upset about these laws, I believe, because it had a positive face. And that positive face was around the meaning of health and eugenics. So it had a meaning that was the exact opposite in some ways of what we think of today. It had an anodyne meaning, a banal meaning, where it meant just, well, we have healthy marriages. There were divorce counselors saying, oh, you should get a divorce if you're not going to have healthy children. Families were considered eugenic. They had contests at state fairs about eugenics. They had books that really were about sex education, but they were labeled as eugenics. And it sort of had an anodyne air for many, many people, which is why I believe that people were not particularly alerted at the time these laws were being passed to the dark side of eugenics, that they could be used in very, very dramatic and evil ways. So fast forward now, we've got a lot of eugenic laws. Fast forward to the 1942 opinion in Skinner versus Oklahoma. The prisoners bring this case. Why? Because they think they're going to be castrated. They're terrified. It takes them 7 years to get to the court. And how do they get the court and why? They don't have any lawyers. The ACLU says, we won't take you. So they hire the local lawyer. He goes all the way up to the Wisconsin Supreme Court. And then finally, they riot. Prison breaks were common at the time. And one prisoner who had rioted before, who had broke prison, breaks again in 1941, in August. If you know anything about Oklahoma in August, it's very, very hot. And they break, and they're just at the end of their, they've gone to the Supreme Court of Oklahoma. They said this is just fine. And they kill the warden. And the warden is very well liked. He's actually a good warden. He has helped the prisoners bring this suit in part and allowed them to do research to try to show whether you inherit criminal traits. And he is supportive of one of the leaders of three who hired the lawyer, Claude Briggs, to bring the suit. By 1941, however, the world has changed. What has changed? We are at war. And they search around for someone in Oklahoma who's actually taken a case to the United States Supreme Court. They find someone. And if anyone knows anything about Amelia Earhart, Oklahoma is a font of flyers So they are really at the edge to file their case in the United States Supreme Court when the break happens. And what happens is when the warden is killed, no one will take the job unless the case goes forward. So the new warden negotiates the case will go forward. And they find a lawyer who commandeers an airplane, flies to Washington in 1941, and gets a stay from Stanley Reed, who is a justice on the Supreme Court. And the court decides to hear the case. And why do they decide to hear the case? The only precedent they have goes the other way. Buck versus Bell says, oh yeah, you can sterilize, you can prevent reproductive rights. There is no such thing. And yet when you begin to read the opinion which Justice Douglas wrote, you will see why the date and the timing is relevant, which Professor Barrett's going to talk more about. But let me just talk a little bit about the case and how it's decided, because it's different than what one might expect today. And in the discussion, we'll talk about that. But its most famous lines are these, and I will read them because I think they're important to the current debate. Justice Douglas writes, and he used to write on a yellow pad and pencil, "This case touches a sensitive and important area of human rights. Oklahoma deprives certain individuals of a right, which is basic to the perpetuation of a race, the right to have offspring. The power to sterilize, if exercised, may have subtle, far-reaching, and devastating effects. In evil or reckless hands," hence the title of my book, "it can cause races or types which are inimical to the dominant group to wither and disappear. There is no redemption for the individual whom the law touches. He is forever deprived of a basic liberty." So begins his opinion. Now, as it goes on, the opinion decides that the real reason the law is unconstitutional is equality, which often causes people today some concern. Well, you started out talking about rights, and now you're talking about equality. This is one reason why people sometimes don't cite Skinner for its rather forceful opening lines involving rights. It goes on to talk about how the law distinguished between chicken thieves, and Skinner himself had been a chicken thief who lost an arm when he stole the chicken. So he was considered unfit for that reason. Who were three-time losers, who had committed crimes of moral turpitude. That's what the statute required. But it exempted white-collar criminals like embezzlers. So the inequality here was about the distinctions in the criminal law. But what's fascinating about this is that it introduces a concept, we talked a little bit about this, or we heard the name of it earlier, called strict scrutiny for the first time in constitutional law. Because Buck had rejected the equality argument. It had not only rejected the rights argument, it had rejected the equality argument. And so to get around that, Douglas creates a new rule. He says, well, you know, in a case like this where there's so much at stake, we have to apply strict scrutiny to this kind of distinction. So he marries the consequences of this, which are irreparable, the liberty interest to the equality interest. Not particularly well, as we'll see from the concurrences and the other opinions that Professor Barrett's going to talk about. But he mixes it up in a stew that had never existed before. Unfortunately, along the way, and this brings us to Act 3 in the conclusion, he never overrules Buck versus Bell. So at the end of 1942, the men of McAllister Prison have won an extraordinary victory. And prisoners will not be sterilized in the future based on Skinner versus Oklahoma. But Buck versus Bell exists. And as Professor Goodwin and Professor Murray have written, what happens is that women are still stuck with Buck versus Bell in many respects, and states continue to sterilize them. And ultimately, this becomes racialized in the 1950s and the 1960s, as they have written about. So just as Justice Douglas indicated, presciently in some respects, that the power to sterilize may have far-reaching and devastating effects. In evil or reckless hands, it can cause races or types to disappear. In, say, North Carolina of the 1960s and 70s, women who were Black were sterilized precisely because they were Black. I will leave you with that sad tale. We're going to continue on with 1942. And Professor Barrett's going to tell us a little bit about the rest of the opinions in the case, as well as Professor Snyder, who knows quite a bit about an addition made by Felix Frankfurter, who I believe knew the link between Nazi Germany at 1942, unlike any other member of the court at the time. So over to Professor Barrett with Professor Snyder weighing in.
Does it have a black background? I want to go dark. Or I'll always have a slide on.
Let me just
That's it.
your screen.
That's fine.
Okay, we're good to go.
Good afternoon. It's a pleasure to be with people, frankly. 2022, this feels like a new weird thing. It used to be familiar to be in academic settings, conferences, lawyer conferences, judges, in numbers. And of course, that all went away, and now it's creeping back, and it's really a delight. And of course, it's familiar and a delight to be virtually with those of you who are out there. I'm very grateful to Professor Nourse for her incredible book and for putting this event together on Skinner Day. It's not a holiday, but it is the 80th anniversary. My particular topic will be to talk about Justice Robert H. Jackson, who wrote a concurring opinion in the case, and how it is a very significant part of his constitutional thinking and his legal career, and how, frankly, it went all the way in a brief, terse statement to see what Skinner's ultimate implications were. Now, let me begin in 1942, and this is a picture of Jackson with Vice President John Nance Garner outside the White House. By the time the Skinner case came to the court in spring 1942, Jackson might well have been in his second year as President of the United States. It might have thus been a very different court because Jackson would have made the appointment of the Chief Justice who succeeded Charles Evans Hughes, who retired in 1941. And he might not have elevated Harlan Fiske Stone, who we're going to talk about. President Jackson also might not have appointed Senator James Burns of South Carolina to the other vacant seat on the court. Who knows, right? But we do know that although there was much Jackson for president in the air in the late 1930s and going into 1940, President Franklin Roosevelt changed his mind, if that's fair. Who knows, really? World events certainly played a significant role. He didn't retire to Hyde Park after 2 terms. He got reelected to the unprecedented 3rd term. And in June 1941, he elevated Stone to be the new Chief Justice to replace Hughes. He appointed Burns from the Senate to replace the vacant seat that had been left by the retirement of Justice McReynolds. And he elevated his Attorney General, Robert H. Jackson, to the court. And so Jackson, age 49, a leading national figure, is the rookie justice in the term that includes Skinner versus Oklahoma. That meant that he wasn't a leader or a significant player on the court. Justice William O. Douglas wrote, this is Roosevelt sending Jackson to the Supreme Court, this is Jackson in his robe. William O. Douglas is the justice who writes the opinion. Justice is in the back row, second from the left. He's not very senior. Stone in the front, in the center, is the one who assigns this to Douglas. And Stone did that for a particular reason, which I will flag. Jackson, you see on the far right in the back row. The junior justice is to be seen and to vote, but not so frequently to be heard from. And Justice Douglas, writing for 7 justices who joined his opinion, held that the Oklahoma Habitual Criminal Sterilization Act, under which Mr. Skinner had been prosecuted in a sterilization trial and convicted, was unconstitutional on its face because it drew arbitrary, irrational lines, classifications, the embezzlers versus the chicken thieves, that violated the Equal Protection Clause of the 14th Amendment. Chief Justice Stone wrote the next opinion in terms of seniority. He concurred only in the result. And the reason he did this, and I think frankly the reason he assigned Douglas, is because Stone as an associate justice had been part of Buck versus Bell. And he had that baggage, and he was not disavowing Buck versus Bell, he was sidestepping it. And he didn't join the equal protection analysis because Buck versus Bell, Justice Oliver Wendell Holmes had mocked that argument, calling it the last resort of desperate litigators. Instead, Stone grounded his concurring in the result opinion simply in procedural due process, that before Oklahoma would perform an involuntary vasectomy on Mr. Skinner, he was entitled to a fuller trial, if you will, than the one that it gave him. And thus, the big shots have spoken in Skinner versus Oklahoma. Robert Jackson's opinion is, in a sense, gratuitous. It's unnecessary, but it comes obviously from something internal and heartfelt. And it's only 4 paragraphs long. So this is Douglas, and this is Stone, and this is again Jackson. And this is the entirety of Jackson's opinion. It's 4 paragraphs. I stitched together 3 lines from a second page, but it's basically a 1-pager. And it's not one of the better known pieces of Jackson's acclaimed career. But my argument here is that it was truly big for him and for his career and for the development of constitutional law since then, which includes how the Supreme Court to this very day and later this month should think about reproductive rights. Now, Robert H. Jackson, you may know, was not over his career an enthusiast for what we would call substantive due process, what some would call more pejoratively judicial activism or living constitutionalism. Think, for instance, of his concurring opinion, a famous one, in the Railway Express case, where he explains the desirability from the perspective of democratic theory of grounding decisions in the Equal Protection Clause. Exactly what Douglas is doing here in the Skinner case, because equal protection leaves the political process a recourse. If something is unequally unconstitutional, the political process can equalize matters and fix the problems, sterilize everyone, or more realistically, as in the Railway Express case, ban every truck from having advertising as it careens through Times Square in New York. Whereas the Due Process Clause, Jackson argued in that concurring opinion, takes issues away from the political process. It constitutionalizes something as fundamental and thus leaves the legislature little to no space to continue to tinker in the area. Or a second example of Jackson's negativity, if you will. Think of his vote with the court majority in Adamson versus California, rejecting the claim that the 14th Amendment incorporates in its entirety the Bill of Rights as restraints upon state governments. Jackson's not a liberal, expansive, living constitutionalist throwing new rights on the table because he has the power as a justice to do that. But, and here's where Skinner starts to be important, he picked his spots. And thus think first of that Adamson vote, which was open to the idea that the 14th Amendment incorporates selected, most fundamental Bill of Rights protections as part of the due process constraint on state governments to protect individuals. And now, circling back to Jackson's first year on the court, think about Skinner. The first paragraph of Jackson's opinion is just the clever pen of Jackson. He says, Douglas decides on equal protection, but doesn't decide on procedural due process. Stone decides on procedural due process, but won't touch equal protection. I join both of them because they should each join each other. Both of these things are problems in the case. Cute, clever, pithy, on to paragraph 2. Paragraph 2 is about procedural due process. It's Jackson engaging with Stone. And he says alternative laws, not what Oklahoma is doing here, might raise different procedural due process questions. A broad, loose classification of who should be sterilized might translate into the need for much more protective individualized hearings. That's not the Oklahoma law. It's not global sterilization. It's 3 times convicted criminals. Also, Jackson says a more narrow classification might require less process if it's really a rifle shot or 2 or 5. That might permit summary hearings and require no need for procedural due process in a trial format. But what Oklahoma has done is something in the middle. And so that's why I think Stone is right too. Again, interesting, not vital. The next two paragraphs are for Jackson, and I think for constitutional law, a big part of the action. He turns to what we would call substantive due process rights. And in paragraph 3, he says, this eugenic sterilization program raises, quote, constitutional questions of gravity. He says, concluding the paragraph, yes, we've got this precedent, Buck versus Bell. It upheld the sterilization of a woman who had been found by the state of Virginia to be an imbecile. And notice how sort of dry, descriptive, non-embracing, kind of checking the box, acknowledging the precedent, nodding to stare decisis, but doing no more than that, Jackson is about Buck versus Bell. Grave constitutional questions, yes, we've got this Buck versus Bell problem. And then paragraph 4. There are limits, Jackson writes, on governments, meaning the political majority of the public's ability to conduct constitutionally, quote, biological experiments on minorities. The language is here on the screen, and it really is worth parsing slowly and carefully. Biological experiments that traduce the dignity, the personality, the natural powers, meaning the bodily functions of a minority, even those who have been found guilty of what the majority calls crimes. But Jackson says, this easy case doesn't raise those ultimate questions. This act falls down before reaching this problem, which I only mention to avoid the implication that such a question may not exist because it was not discussed. On it, I reserve judgment. Now, as a reservation of judgment goes, this is waving a big red flag about the concerns that he has. And this constitutional dignitarian concern for natural bodily powers becomes part of the protective legal vision that is a defining aspect of Robert Jackson's life and career. I'll flag a couple of different columns, if you will. First, you see it in his Supreme Court judging. You see it in his concurring opinion the previous fall, his first opinion on the Supreme Court in Edwards versus Oklahoma, where the court struck down the anti-Okie California no travel statute. And Jackson said freedom to travel is a privilege and an immunity of citizenship in this country. And what is freedom to travel? It is a bodily function, a very G-rated one, but it is walking or driving or schlepping from here to there. And Jackson puts that marker down in his first opinion. A second opinion, his most famous perhaps, in his opinion for the court in West Virginia State Board of Education versus Barnett, the next year after Skinner. So now we've gone from fall of 41, June of 42, June of 43 is when Barnett is decided. Jackson writes for the court, striking down the state's compulsory flag salute and Pledge of Allegiance law, overruling the Gobitis decision of a few years earlier. And Jackson writes this sentence, which is the conclusion of the opinion, much quoted. The very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of minorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, a free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections. And now think a minute about what Barnett was actually about. These two Jehovah's Witness schoolgirls had religious scruples against pledging allegiance to the flag, because the book of Genesis says, thou shalt bow down before no graven images. There's one true God, the God Jehovah, is their belief. But what the state of Virginia was trying to do was force its orthodoxy into their mouths, a kind of inchoate physical intrusion. And it's that compelled profession coming back out of their mouths, out of their bodies, that Jackson is drawing the line against in Barnett. A third decision. It's there in Jackson's dissent in Korematsu versus United States, where he's one of the three justices who votes that the exclusion order against Japanese Americans, including a vast majority of citizens during World War II, was unconstitutional. That, of course, is a Fifth Amendment substantive due process decision. And Jackson says Fred Korematsu didn't choose to be Japanese American. And the federal government chooses to use that to physically relocate him by ordering him excluded from the West Coast. His body ordered to a racetrack. Jackson says our Constitution does not permit the racializing of criminal procedure. And a fourth opinion, or a fourth vote. Jackson joining Justice Frankfurter's opinion for the court in Rochin versus California in 1952, where the court unanimously, with some division in rationales, strikes down the forcible stomach pumping of a man to extract physical evidence of drug crime. Jackson voting for the body against the government's ability to mess with it. Am I saying that Jackson's jurisprudence led the charge? No. I'm saying Jackson's jurisprudence sprinkled the seeds to understand that as fundamental rights go, the body is very high in the hierarchy. And of course, Robert Jackson did more than judge. This is Harry Truman in 1945 appointing Robert Jackson to be the US chief prosecutor of the Nazi war criminals at Nuremberg. And Jackson goes and misses a whole year of the Supreme Court to prosecute in this courtroom the wagers of aggressive war, the perpetrators of the Holocaust, and all the dimensions of physical subjugation, violence, extermination that Nazism contained. This is Jackson at the podium, opening that trial in November of 1945. And these are the defendants who were perpetrators of command decisions that were part of bodily violence, among many other crimes. Jackson is at Nuremberg is standing for the same principle that he's articulating in the Skinner concurrence. And this isn't just, well, let me pause. Am I saying that Robert Jackson would have been the eighth vote in Roe versus Wade? An anachronistic question, of course. He died in 1954. But if you think about better cardiology, he's only 80 years old if he lives to 1973. Younger than Stephen Breyer is today. Or am I saying that if Robert Jackson was the longest living person in American history, he would have been a sixth vote in Casey? That's where Skinner and Nuremberg and all of this points. But was it really all there in 1942? Yes, to a close and discerning reader. This is a letter that an assistant U.S. attorney in Buffalo, New York sent to Justice Jackson, June 8th, a week after Skinner. His name is Robert Hitchcock. He later was part of a big New York State law firm, Phillips, Lytle, Hitchcock, etc. And young Hitchcock is acquainted with Jackson, and he writes this letter complimenting his concurring opinion. And he focuses on the statement that there are limits. In other words, the paragraph 4 statement. And Hitchcock unfolds this, says, sterilization is a powerful weapon. Once the principle is approved, in a single generation, our self-constituted supermen can eliminate Jews, communists, Democrats, bankers, or any other group or class. Mendel's law. And in the last paragraph, he makes a joke about Shakespeare's line about first, let's kill all the lawyers. Jackson's response, dear Bob, from Bob to Bob Hitchcock, is thanks and jokes about the lawyer joke, but doesn't disavow any of the heavy reading of paragraph 4, that there are limits concept. The import and breadth of Skinner came to be understood better over next decades. The Supreme Court cites it, builds on it in Griswold versus Connecticut versus for contraception for married couples, Loving versus Virginia, interracial marriage, Eisenstadt versus Baird, general individual rights to use contraceptives, Roe versus Wade, of course, and Planned Parenthood versus Casey, of course. And to some extent, this all grew out of seeing Skinner as huge. Professor Nourse's book allows us to see it as historically huge, but to see it as constitutionally huge, I think the primary credit goes to Professor Lawrence Tribe of Harvard Law School, who in his treatise in 1978, American Constitutional Law, said what Skinner stands for is strict scrutiny, but not just of fundamental rights, not just the Bill of Rights, and not just things that are otherwise protected in explicit constitutional terms like race. But it's also individual interests that aren't yet recognized as fundamental, but are the areas where the government could make choices for people about the things that matter most to them, their bodies, where the danger is too great. The majority power would do this to oppress and to subjugate minorities. In other words, Skinner is a gateway to a category of new fundamental rights, wrote Professor Tribe. And in explaining that, he says, It is a star that the Supreme Court added to the constitutional firmament. And if you know Robert Jackson's opinion in West Virginia Board of Education versus Barnett, that's not far off, and it's clearly a little bit influenced by Jackson's description of the fixed star in our constitutional constellation. And Tribe credits Douglas and credits explicitly Jackson. So, in conclusion, as Jackson in Skinner felt and explained, our Constitution is about many things. But liberty and equality, intertwined, as Professor Tribe has explained, in the bodily realm, is at the heart of what our Constitution is about. This is my body, and that is yours, and yours, and yours, not the government's, except in truly extraordinary circumstances that maybe can never be envisioned. And in the specific realm of sexual capacity and reproductive function, that means that government should trust each of us equally, and it should respect the liberty of each of us fully with regard to our bodily functions. That means, among other things, to have heterosexual sex or not, to seek to impregnate or to become pregnant or not, and to continue to be pregnant or not. And what of all the Nazi talk that can be lobbed against government actions? I think it dilutes history and cheapens argument to call a government that makes any choices for people a Nazi government. There was only one of those, and we should remember it in its reality. On the other hand, understanding that government, which is deeply restrictive of liberty and hostile to fundamental equality, is attacking something unitary in each of us and vital and fundamental in each of us, is a lesson we take away from the 1940s and from Nuremberg. These are not ways that a decent, dignified society should constitute itself. In our legal system, which requires government to provide due process and equal protection, it is not how we are constituted. So thank you, Jack Skinner, his lawyers, Supreme Court, Robert H. Jackson, for standing up 70, 80, and more years ago for that, and for teaching us now.
Thanks, John, for that tour de force on Justice Jackson. After I talk a little bit about Justice Frankfurter's role in this case, Professor Murray is going to speak next, not Professor Goodwin. That's on me. But before we do that, I want to take us back to 1942 for a minute and just remind people about the holding in Skinner. The holding in Skinner is an equal protection rationale, a rationale that most people believe is due to the influence of Felix Frankfurter on the decision. And let me tell you how we got there. As Victoria alluded to, Frankfurter was really privy to what was going on overseas, perhaps unlike any other justice in 1942, and there's a couple of reasons for that. One, since 33, Frankfurter had been, when he was a Harvard law professor, he was a chief outside advisor for Franklin Roosevelt. He continued that role as outside advisor to Franklin Roosevelt after Roosevelt appointed him to the Supreme Court in 1939. Judicial ethics then were as challenging as maybe they are today, right? Not only that, Frankfurter was instrumental in getting Henry Stimson appointed Secretary of War as an acting Supreme Court justice, and one of his former students, John McCloy, was serving as one of Stimson's chief assistants. And on the regular, Frankfurter was having conversations with both Stimson and McCloy about the war and about the atrocities the Nazis were committing in Europe against Jews and others, and gypsies, and all others who weren't part of the quote-unquote Aryan race. Not to mention the 9 years since the rise of Hitler that Frankfurter had been working on this issue of trying to get Jewish refugees out of Europe, Jews out of Europe and to Palestine and to the United States. So all of that is sort of a backdrop of this. But I don't think any of that had to do with Frankfurters pushing his colleagues to adopt an equal protection rather than a due process rationale. Frankfurter believed there shouldn't be a due process clause in the Constitution. He thought it should be written out of the document. And the reason why he thought that was because he opposed the idea of judicial supremacy, and he thought that the due process clause gave the justices too much power. He saw the court as reactionary and particularly anti-labor. And throughout the early part of the 20th century, the court used the liberty provision of the due process clause to strike down lots of pro-labor legislation. So he was loath to sign on to an opinion with a due process clause rationale, and he didn't distinguish between good due process decisions or bad ones. Let me give you two examples. Meyer versus Nebraska, 1923. That was a law that was passed to ban the teaching of foreign languages in schools in the state of Nebraska. It was an anti-German law. Pierce versus Society of Sisters, 1925, was an Oregon law inspired by the Ku Klux Klan to try to shut down all the Catholic schools in the state by requiring school children to attend public school. The court sided with the quote-unquote angels in both of those cases on expansive views of the due process clause, struck down both of those laws, and Frankfurter thought they were wrongly decided. That this should come down, that most of our constitutional change should come through the political process and not from the Supreme Court of the United States, expanding like an accordion the due process clause. He was a Thayerian, right? He thought, particularly when it came to federal laws, that the court shouldn't be striking down federal laws unless they were unconstitutional beyond a reasonable doubt. Now, he had a few exceptions. He was very willing to side with criminal defendants like in Skinner. He was also very much in favor of what today we would call civil rights, and was a leader in the court's move to get a unanimous opinion in Brown versus Board of Education. The other thing that he didn't like, and that hasn't been talked about yet, was Chief Justice Stone's footnote in Caroline Products. And that's really the start of this idea of strict scrutiny in Skinner, right? In footnote 4, Caroline Products, Chief Justice Stone famously writes, famous today, but not then, right? Famously writes that the court will take a harder look at cases that infringe upon the Bill of Rights, or the political process such as voting, or discrete and insular minorities. Frankfurter was skeptical of this Caroline Products approach as, again, giving the Supreme Court too much power to decide when there was a quote-unquote defect in the political process and it should weigh in. So he very much favored a kind of judicially minimalist equal protection rationale that the state of Oklahoma wasn't treating similarly situated people the same way by making embezzlement not a crime of moral turpitude, but making stealing chickens or robbery a crime of moral turpitude. The state of Oklahoma was treating equal things unequally. And that was, I think, Frankfurter's way of deciding on behalf of these criminal defendants, but not creating another expansive substantive what today we would call substantive due process decision. I'm going to hand it off to Melissa and Michelle, in case you're bored about 1942 and want to talk about the present day. Melissa, on to you.
Hi there. Apologies for not being able to be there with you in person today, but I'm really excited to have this conversation with everyone. And I think it's a really timely conversation. So I will begin first by just sort of noting my priors here. I think there are a lot of things that we could say at this moment about the current landscape for reproductive rights, but I appreciate that this event is focusing on the past as a vehicle for understanding our present and possibly forecasting what lies in the future. And so I wanted to focus our discussion on two very recent writings from the Supreme Court, the Box concurrence from Box versus Planned Parenthood of Indiana and Kentucky, a 2019 decision, and of course, the leaked draft opinion in Dobbs versus Jackson Women's Health Organization. So let me first begin with the Box concurrence. In May 2019, the Supreme Court issued a per curiam opinion on the shadow docket in Box versus Planned Parenthood of Indiana and Kentucky. And that case was a challenge to two Indiana abortion restrictions, one of which was a trait selection law that prohibited abortion if it was intended for purposes of race or sex selection or because of the diagnosis of a fetal anomaly. And interestingly, although the court in a per curiam opinion granted certiorari as to one of the challenge provisions, it denied certiorari as to that challenged trait selection law. And the fact that the court refused to hear a challenge to the trait selection law prompted Justice Clarence Thomas to write a separate concurring opinion. And there he chided gently the majority for denying cert. And that might have been the end of things. But Justice Thomas went further, crafting an opinion in which he not only insisted that the court would one day have to deal with the prospect of trait selection laws and whether they were simply modest attempts by the state to prevent abortion from fulfilling its quote unquote eugenic potential. And then he further went on to craft a history of eugenics in which he conflated the history of abortion and the birth control movement and linked it to the history of eugenics in the United States. As Justice Thomas explained, Margaret Sanger, the founder of Planned Parenthood, had worked hand in glove with the eugenics movement to spearhead efforts to expand the use of birth control within the Black community, ostensibly for the purpose of stamping out Black reproduction. Justice Thomas was no doubt thinking about the disproportionate rates of abortion among the Black community today, and perhaps viewing this disproportionate rate of abortion as the contemporary residue of an earlier effort to market family planning to the Black community. Then Justice Thomas specifically invoked Buck versus Bell, which we've already heard about today, the 1927 case in which the court famously credited Virginia's eugenics program, which targeted those deemed quote unquote feeble-minded, and where the court, according to Justice Thomas, lent its imprimatur to the eugenics movement, famously intoning that 3 generations of imbeciles is enough. At this point, Justice Thomas circled back to the challenged Indiana trait selection law, observing that such restrictions were indeed the state's modest attempt to ensure that eugenics could not be used to fulfill its eugenic potential, or that abortion could not be used to fulfill its eugenic potential to eliminate unwanted traits or characteristics. Now, when it was announced, the concurrence received some attention, but it was quickly overshadowed by other major developments at the court that term. But it's incredibly fascinating concurrence, in part because it's entirely gratuitous and because it touches on so many things that we are currently seeing in our current reproductive rights landscape. And in particular, I want us to understand the concurrence as an attempt by Justice Thomas to recast the contemporary meaning of abortion, both in legal doctrine and in society. So one of the ways that abortion justice, our reproductive justice advocates have argued is that impositions on the abortion right are not simply assaults on women's autonomy and equality, but that they disproportionately impact women of color and poor women, and therefore they should be understood as posing intersectional harms. It struck me as I read the Box concurrence that Justice Thomas seemed to recognize the way in which the reproductive justice movement had helped to shift the debate about abortion and reproductive rights away from this question of equality and autonomy for women, and had instead reframed it as a question of racial justice, or rather racial injustice. So specifically, if the reproductive rights movement, in tandem with the reproductive justice movement, had argued that abortion and reproductive rights were about ensuring women's equality and racial justice, Justice Thomas's concurrence turned that logic on its head to counter that the real racial injustice that was being done was not what abortion restrictions did to communities of color, but rather what abortion itself does to those communities. So on one level, the Box concurrence offers a defense of trait selection laws that has already been percolating in the lower federal courts. And indeed, in the Seventh Circuit's disposition of Box, Judge Frank Easterbrook wrote a dissent in which then Judge, now Justice Amy Coney Barrett joined, in which he suggested that trait selection laws might fall outside of the scope of Roe versus Wade and Planned Parenthood versus Casey, because those cases had never considered abortion restrictions that were not aimed at promoting women's health, but instead were positioned as fetal anti-discrimination measures. So trait selection laws, he argued, were merely attempts to prevent discrimination against different kinds of fetuses. The Box concurrence provided additional support for this idea that state-level restrictions on quote-unquote eugenic abortion function as anti-discrimination measures and thus are outside of the scope of Roe and Casey. But that's not all the Box concurrence does. So in the short term, it does offer that defense of trait selection laws. But as I argued in a piece in the Harvard Law Review, the Box concurrence actually goes further to lay a foundation for overruling Roe versus Wade and Planned Parenthood versus Casey on the ground that the right to abortion does not begin in 1973 with Roe versus Wade, but rather that its roots are actually even earlier in the 1920s with the eugenics movement and in the racial injustices of that eugenics movement. So to be clear, one of the important contributions that the Box concurrence makes is to provide a language for talking about Roe and specifically for overruling Roe that is rooted in rooting out racial injustice and remedying that racism. And there's a lot of history in our constitutional past for overruling cases on the ground that they are rooted in racial injustice. All we have to do is look to the most famous case in constitutional law, Brown versus Board of Education. This was a case that was not only famous to law students, but indeed figured prominently in the oral arguments in Dobbs versus Jackson Women's Health Organization on the ground that this was an example of a case where the court had appropriately departed from stare decisis to overrule a past precedent, Plessy versus Ferguson. So in Brown, the court revisited Plessy and determined that it had not fully taken account of the racial and psychological damage that segregation posed to Black school children. And for that reason, the court departed from stare decisis and overruled Plessy versus Ferguson. We've seen more recently similar impulses toward correcting and remedying racism and racial injustices as the court has overruled other earlier cases. So consider, for example, the October 2019 case, Ramos versus Louisiana, which invalidated Louisiana's policies of allowing criminal convictions to proceed from a non-unanimous jury verdict. The question of whether non-unanimous juries were consistent with the Sixth Amendment had already been considered in 1972's Apodaca versus Oregon. Nevertheless, the Ramos court concluded that because Apodaca was out of step with extant Sixth Amendment jurisprudence, and because the Apodaca court had failed to consider the non-unanimous jury rule's origins in a Reconstruction era effort to entrench white supremacy, the 1972 decision could properly be reconsidered and overruled. The court's disposition of Ramos suggests how Roe could similarly be revisited and overruled on grounds of racial injustice. Justice Thomas's racialized critique of abortion furnishes, I argued, new justifications for reconsidering and overruling that embattled decision. And specifically, these new factual circumstances that Justice Thomas had surfaced linked Roe to a history of race and racial animus that could render Roe a remnant of an abandoned doctrine. So for that reason, I was especially interested to read the leaked draft opinion in Dobbs versus Jackson Women's Health Organization. Now, notably, in the text of the opinion, Justice Alito, who wrote for the ostensible majority, did not reference eugenics at all. But even more meaningfully, in a nod to the Box concurrence, there is considerable discussion of eugenics in a footnote in that decision, footnote 41. There, Justice Alito observed that a series of amicus briefs filed before the court in Dobbs had, quote, noted that some such supporters of liberal access to abortion have been motivated by a desire to suppress the size of the African-American population, end quote. He then went on to say that it is beyond dispute that Roe has had that demographic effect. A highly disproportionate percentage of aborted fetuses are Black. I want to just stop and ruminate on that footnote. As we've all discussed over the last couple of weeks, The decision to overrule Roe versus Wade has nothing to do with eugenics. Instead, Justice Alito links his antipathy for Roe versus Wade and Planned Parenthood versus Casey to the fact that the right to an abortion is unenumerated and is not deeply rooted in the history or traditions of this country. For that reason, it seems entirely gratuitous that this footnote appears in the draft opinion. There's no need for it. They've already decided that Roe is egregiously wrong, that they don't need to stand by stare decisis because this is an unenumerated right that is not deeply rooted in the nation's history. So why then is this footnote included? Like, is it simply a nod to Justice Thomas, a kind of collegial gesture that one justice might make to a colleague? Perhaps. Or more interestingly, as I've argued elsewhere, this again creates the conditions where reproductive rights are inextricably linked to eugenics. And while that may not necessarily have repercussions for abortion once Roe is overruled on other grounds, it may lay the groundwork for countering other reproductive freedoms, including the right to access contraception. And indeed, the argument that Justice Thomas crafts in the Box opinion about the link between Margaret Sanger and the eugenics movement is perhaps most forceful in condemning birth control and access to contraception as linked to the eugenics movement. So that's one thing that we might take out of the Dobbs opinion, despite Justice Alito's efforts to sequester the question of abortion from other reproductive rights and other freedoms that are also unenumerated. This particular footnote might suggest that the majority is already laying a foundation for rethinking and perhaps indeed discrediting contraceptive access going forward. So all of this suggests the effort to link abortion and contraception to the racialized logic of eugenics is very interesting on a number of fronts and very revealing on a number of fronts. The effort to recast the social meaning of reproductive rights from a question of gender equality to one of racial inequality is especially noteworthy, and indeed perhaps is even utterly disquieting, because what this narrative does not do, and what it neglects entirely, is the degree to which the eugenics movement's true investment in reproductive rights and in controlling reproduction was not in abortion or contraception, but rather in coercive sterilization, its preferred vehicle of reproductive control and social engineering. So with that in mind, I want to consider what it would mean for us if we reframed this newfound interest on the right in reproductive rights and racism and eugenics to focus less on abortion and contraception and more on a robust discussion of sterilization practices. What if we supplemented the historical narrative to clarify that the eugenics movement's interest in racial betterment was directed primarily at improving and purifying the white race, that it was a tool of white supremacy aimed at optimizing whiteness, not necessarily stamping out Blackness? What if we acknowledged that to the extent the eugenics movement focused on abortion and contraception at all, it was in limiting middle and upper class white women's access to those vehicles of reproductive freedom on the ground that the reproduction of those constituencies was absolutely vital to the future of the white race? What if we were to acknowledge that insofar as eugenicists were interested in limiting reproduction, their interest was not directed at the Black community, but toward those individuals who possessed traits deemed unsuitable for the propagation of the white race? People like Carrie Buck, who was poor, undereducated, and unchaste. People like Jack Skinner, who was a chicken thief. And meaningfully, what if we were to take seriously that the true eugenic threat that lies in reproductive rights lies in our refusal to consider sterilization as part of the universe of reproductive rights as much as abortion and contraception? And at this point, it's worth looking beyond the 1940s. All of the speakers so far have talked about the waning days of the eugenics movement and the rise of Nazism and the taint of Nazism and how it very much affected the legitimacy of the eugenics movement in the United States. What we haven't talked about is that even though that was the case and the social fervor for eugenics did die out in the 1940s, Eugenic sterilization was repackaged under other guises, especially in the 1960s on the heels of the civil rights movement and the welfare rights movement that had expanded the scope of public assistance to include poor women of color. To understand this relationship between race, class, and dependence on the state, we might consider the case of Cox versus Stanton, a challenge to North Carolina's sterilization program that was litigated in the 1970s by Ruth Bader Ginsburg and Brenda Fagan-Fasto of the ACLU Women's Rights Project. Cox concerned the claims of Nile Ruth Cox, who had been subject to coercive sterilization as a teenager because she had already given birth to a child outside of marriage and because her mother and her siblings were in receipt of public assistance. Her family was told that if she did not submit to sterilization, they would lose their access to public assistance, something that her mother could not afford to do. As Ginsburg and Fastow argued, North Carolina's sterilization program had utterly violated Cox's constitutional rights, condemning her to infertility and dooming her chances for marriage and quote unquote, a normal family life. Ultimately, however, the Cox case did not result in the invalidation of state sterilization programs. The case was deemed moot because North Carolina voluntarily phased out its program. But other contemporary challenges to sterilization abuse, the Madrigal 10, the young women, the Ralph sisters in Mississippi and Alabama, all of this made clear the centrality of sterilization as a technology of reproductive control well into the 1970s. And interestingly, more recently, in 2020, in September of 2020, we were faced with a massive scandal in ICE detention when it was argued that women in ICE detention who had been detained by the government were being subjected to coercive sterilization without informed consent and often without the benefit of a translator. That story occupied our attention for all of 1 week. And then, perhaps ironically, the news cycle shifted. Just as Ruth Bader Ginsburg passed away on September 19th of 2020, and her passing utterly drowned out the fate of those women in ICE detention and the prospect of a contemporary conversation about real-life coercive sterilization within our borders. So today, as we think about all of these different threads and attempt to bring them together, I hope that we will think about this nascent effort to associate abortion and contraception with eugenic racism, and think about how it not only affects this contemporary discussion of the future of Roe versus Wade, but how it also overlooks and occludes the real life state-sponsored reproductive abuses that we continue to live with in our very country and that continue to plague certain communities in our country in ways that are clearly unequal and utterly unjust. So I'll stop there.
Thanks, Professor Murray, for that really powerful presentation. Professor Goodwin?
And I too want to thank Professor Murray and also my colleagues on the panel. Thank you so much, Victoria, for organizing us and bringing us together. So as I wrap up our panel's discussion, transitioning from Professor Murray provides a great pathway for me. I think about 1851 and Sojourner Truth's speech, Ain't I a Woman? And for much of history, what's been unpacked about that is that she spoke about chivalry. And what is curiously missed is at the beginning of the speech, as she says, and I bore 13 children and saw nearly each one snatched from my arms, and nobody heard my cry but God. Ain't I a woman? Now, this is a time that is preceding the Civil War. And the reason why I take a page from history that goes back perhaps a chapter before the conversation that we've grounded today in eugenics is to really help to set the stage about what is staring us in the face, the potential that Roe v. Wade may be fully dismantled by this United States Supreme Court. And as Professor Murray mentioned, over the last few weeks, we've all been stunned a bit by a leaked draft opinion. The draft itself is highly unusual. It is a story, but not the story. And the reason why the timing of that speech is important to this discussion is that what's overlooked significantly, but there is some nod to it in Roe v. Wade itself, is the fact that abortion had not been criminalized historically in the United States. The Pilgrims performed abortions, indigenous people performed abortions. Abortion becomes a political wedge issue and a tool in the period leading to the United States Civil War. At about that time, nearly 100% of reproductive health care in the United States had been performed by women. These were the midwives. And if you pause and think about it, that's not a curious thing, right? There are no guys with lab coats and stethoscopes roaming around millennia ago, the plains of Africa, Asia, or anywhere else. No, gynecology and obstetrics becomes a field that develops in the 1800s. If you read the works of Horatio Storer and Joseph DeLee, you notice their deep insecurity. What we call medical schools today were schools of anatomy. And what you notice in their pamphlets, which they called books, were ways in which they felt very intimidated by and threatened by the guys of anatomy, who claimed that they were doing nothing special. In fact, they were doing women's work. In fact, doing nothing really elevated, because half of the people in the country that were doing that work were, in fact, Black women. It is not that that's a story alone. It is that that story must be understood as part of a perfect storm of what is happening. The rise of gynecology, because by this point, there are the tools of gynecology that were being perfected, notably being perfected in ways that I, as a bioethicist and others, find alarming, deeply alarming, because enslaved Black women were used as the guinea pigs, euphemistic guinea pigs, in the development of obstetrics and gynecology. Famously, Marion Sims, who once had a statue in Central Park, which very recently was yanked, wrote in his autobiography about how he would rouse in the middle of the night the enslaved Black women that he kept at the back of his house, because he would have an epiphany and he would cut into their bodies, stash, lacerate, do all sorts of things like this. And he writes about this in his autobiography. And it's worth taking a pause here to think about who gets to tell the story, who gets to sit on the stage. I was alarmed when I read that autobiography, but by that time there were already statues of Marion Sims in Central Park and all across the country. He was already considered the godfather of gynecology. He was praised by men of medicine. And yet, if you read his words, not the words of Black women describing the horror and the terrorism that he inflicted on Black women's bodies, but his own words that described it, and how he believed that Black women did not feel pain. And so as he would cut into their bodies, denied them any kind of relief. But it is this perfect storm of the building of gynecology, is this perfect storm of the coming of the Civil War, that leads people like Horatio Storer, Joseph DeLee, and others to write about the urgency of white women spreading their loins north, east, south, and west. Abortion becomes an expedient political tool for the men of medicine to be able to shut women out. And you see it quite directly in their writings. They lean into medical organizations and legislation, legislators who are quite keen on preserving slavery, who are quite concerned about a kind of terminology that we're hearing today, replacement theory, this notion that somehow, if in fact the Civil War comes, in fact, if Black people are released from the bowels of slavery, that they will darken the United States. And so they write about the cruelty of these midwives, the unsanitary nature of these midwives, the evil nature of these midwives, the immoral things that they're doing. But ultimately, it is a mode of capitalism. It is a mode of monopoly. It is a way to shut women out, and they're successful. This campaign, which again is part of a perfect storm, is effective. We go from the 1800s, where women are in control of about 100% of reproductive health care. And again, it's not surprising, right? To by the time of the early 20th century, down to 1%. And I think that that is really worth noting. Now, if we think about racial hierarchy beyond that, Sojourner Truth, the kind of coming of the Civil War, then we'll know that racial hierarchy has long been the euphemistic elephant in the room and the American dividing line demarking power, freedom, and self-governance. And I want to take a moment to basically cross off a few issues here. One, talk about race as proxy for the political power and how we see that in this moment, building off of what Professor Murray has said. Tie this historical thread and then move us to the present and what I would call the new Jane Crow and what comes next. And so to properly undertake the examination of what we could call eugenics as a form of racial caste in the United States really requires engaging beyond law, reaching to the fields and tools of sociology, ethnography, anthropology, history, to unpack not only law's racial trap, undisguised by legislation such as the Fugitive Slave Act or myriad cases, but also the lasting and even haunting social, cultural, and rhetorical norms and mores in our society that would lead us to believe, or some people to believe, that what was articulated in Justice Thomas's concurring opinion and in this robust footnote would actually be accurate, the robust footnote, that footnote 41 that Professor Murray spoke to. So first, let me talk just really quickly about the ways in which law has been complicit. And I think it's really important, and what my co-panelists have talked about is the way in which law has rooted so much of this. And if we again take chapters back and thinking about eugenics as part of creating racial caste, well, the die for that was already set. And if you can think about it across a few areas, one, matrilineality in the United States. Some of the first laws in the colonies and in the United States were those that were designed, that designated that all children born of enslaved women would by law inherit the status of their mothers. This proved important in denying the multiracial offspring of white plantation owners independence and freedom. As defined, matrilineality served multiple purposes. It shielded white men from legal and financial obligations to their Black offspring. Such laws meant that Black children of white fathers could never establish paternity, freedom, citizenship, and the inheritance of rights. Such laws exploited Black women's sexual vulnerability to the predations of white men. Slavery perversely incentivized white male slaveholders' sexual assaults on their enslaved property, that enslaved property being Black women. And these Black women notably lacked rights and could not lay claim even to their very own offspring, nor spare them from enslavement. Black women and their offspring were all considered the property of the persons who owned them. And it's worth noting that this was not just an enterprise of white men owning Black people, white women did too. But to further see the tools of law in the chapters before eugenics then would mean moving to hypodescent. Again, laws crafted in the United States before eugenics that mandated that anyone with any African biological heritage would always legally be designated as Black, and therefore legally, by law, right, inferior. And then we have the third guardrail in the kind of protection of law's protection of whiteness before I even get to eugenics. And that happens to be anti-miscegenation, this idea that people should be barred from marrying people outside of their own race. And specifically, this was about creating guardrails around whiteness. And now we get to eugenics. And eugenics is an important conversation to be had, and I will get to the present. Believe me, I will. But it is worth noting that eugenics was importantly, and as mentioned by Professor Nourse, something that was not a kind of Black-white enterprise. There were 36 different categories of whiteness at the turn of the 20th century. Eugenics significantly was about policing whiteness and the boundaries within whiteness and also outside of it too. And it's worth noting that there were law cases that often are not evoked in conversations like this that deserve to be. Eugenic practices in the United States further demonstrated the policing and the boundaries of whiteness, but courts policed it not only inside, but also outside, giving further evidence and weight to racial caste in the United States. Legislatures and courts reserved whiteness, which conferred privileges and rights only for people who appeared white. And here, those of you who know the cases I'm about to talk about, Ozawa and Thinn. The Ozawa v. United States case in 1922, the court said the provision is not that Negroes and Indians shall be excluded, but it is in effect that only free white persons shall be included. The intention was to confer the privilege of citizenship upon that class of persons whom the fathers knew as white, and to deny it to all others so classified. These were cases that were back to back where Asians were suing to become essentially white. Now, they didn't really want to become white, but being black was so awful. Jim Crow laws, thousands of them relegated people to second-class citizenship, black people. And so we see in the early part of the 20th century, Asian folks suing and cases coming to the Supreme Court, challenging this, seeking to become citizens, and by means of that, challenging the notion of what is white. We see in the case following that, and here I'll just quote from the United States v. Bagot-Thin case and then speed us up to the present. Justice Sutherland wrote, stating, "It may be true that the blonde Scandinavian and the brown Hindu have a common ancestor in the dim reaches of antiquity, but the average man knows perfectly well that there are unmistakably and profound differences between them today, and it is not impossible if that common ancestor could be materialized in the flesh, we should discover that he himself sufficiently differentiated from both of his descendants to preclude his racial classification." Now, what did all that gobbledygook mean? Essentially, the court said, effectively, we know what whiteness is by the way we look at it, right? And these were ways of policing those boundaries of whiteness. So what does that mean today? What does that mean for this footnote 41? What does this mean in terms of Justice Thomas's concurrence? Well, Roe v. Wade may soon be dismantled itself. And what we see in Justice Alito's leaked draft opinion is a turn to history, but it is a selective turn to history. It is curious. There are multiple omissions and cherry picking through history itself. There is a turn to looking at the works of Sir Matthew Hale, someone who wrote about coverture, which essentially meant that women would have no independence themselves, coverture being used as the tool of law to justify marital rape, and also to justify the horrible instances of fathers being able to rape their daughters and seeing no consequences from that, out of the notion of parental immunity, and U.S. courts, state Supreme Courts, articulating that for daughters to be able to sue their fathers would essentially mean disrupting family harmony. This is the history that Justice Alito cites to in the draft opinion that may serve as the basis for dismantling Roe v. Wade. Now, what is to come from all of this? What are the real world effects? And I want to close on this, and really we could spend a whole weekend digging so deeply across all of this. But the real world consequences take me back to Sojourner Truth and talking about the 13 children being snatched from her arms and no one hearing her cry but God. If you look at Whole Woman's Health v. Hellerstedt, Justice Breyer cites a study that's been picked up by the CDC and data that is so well known, which is that a person is 14 times more likely to die by carrying a pregnancy to term than by having an abortion. This is data that is it's not controversial in that it's controversial in terms of the substance, but not the robust evidence that we have. And if we're to take any kind of nod and pause on what Sojourner Truth said so long ago, we might think about what this means in contemporary terms in Mississippi, where a Black woman is 118 times more likely to die by carrying a pregnancy to term than by having an abortion. Nationally, Black women are 3.5 times more likely than their white counterparts to die by carrying a pregnancy to term. But let's be clear, this is no panacea for anybody in the United States, given that the United States ranks 55th in the world in terms of maternal mortality. That is, the United States is not in the company of other industrialized nations, air quotes around that, but it's not in the company of Sweden, England, Germany, or France. No, the United States sits in company with Saudi Arabia and countries that tolerate the public lashing of women, that tolerate the stoning of women. That's where the U.S. is. Now, what comes forward? Justice Alito has claimed that there are guardrails potentially, that Roe could be dismantled, but there are guardrails that would protect contraceptive access, that might protect interracial marriage, same-sex marriage. Well, that's hard to countenance when you see coming from the very states that are proposing the most aggressive anti-abortion laws, already legislators making claims that they next will, in fact, seek to make sure that contraceptive access is not available in their state, such as IUDs. This wording in the league draft opinion may mean very little given the signal that it sends, perhaps to clerks that may refuse to issue a marriage license to a same-sex couple or a couple that happens to be interracial. There's more that I could speak to, but I actually want to pause so that we can give time to the discussion that we can have as a panel here. And let me just close by saying this. One of the things that I find most alarming by where we are today, and in fact with this leaked draft opinion, is that there's a level of cruelty, and some might say that cruelty is the point. Nowhere in the leaked draft opinion is maternal mortality mentioned except in reference to Roe v. Wade, and just within one paragraph of that. A feature of the anti-abortion legislation today, something that we wouldn't have seen even a few years ago, are no exceptions for rape or incest. None of that is taken up in this leaked draft opinion. What in the world could we call this? What would we call it in any other context, given what just is at stake in our country? Thank you.
Thanks so much, Professor Goodwin. I think now we're going to take questions and try to open up the floor. First, to the people who are here in the audience, I have a couple of questions online that I'm going to read as well. But is there anyone in the audience who wants to ask a question before I start in on the online questions? Let's wait for the microphone real quick. Thank you.
Thank you for being here. I'm curious. There's been like a lot of originalist scholars who've critiqued the Alito draft, a lot of the original public meaning scholars. And so, especially because abortion was legal in all the colonies at the time of the founding, the 27 states cited for the 14th Amendment is actually not accurate. It was less than a majority. So I'm just curious, like, do you think that there's room for an alliance, like sort of among non-originalist and originalist scholars and people who think this way on this topic? It seems to me there should be.
Well, I'll just begin and let anyone else since I focus on methodology. But I'd be interested to hear what the other panelists have to say. I don't know if there's an alliance. I think we'd be happy to to have the the originalists have been out there talking about why there are errors in these opinions. It's now clear. This is why the Alito opinion, in my view, will not read that way when it is issued. I also believe, and this is just my guess based on last term, I've been studying every opinion in like the full universe of opinions in an article I just gave up at Harvard. And it looks very much to me like a case called Fulton, which involves religious rights, in which Justice Alito writes a very aggressive concurrence. And this looks like a concurrence to me. And so that the main opinion may look nothing like this. Even though they're going to uphold, I expect there are 5 votes to uphold the and perhaps overrule Roe versus Wade, and therefore uphold Mississippi law. Now, could there be an alliance? Yeah, I mean, historically, people have made a very simple textualist argument that, in fact, I've been saying that Madison would be rolling over in his grave because the 9th Amendment was in there precisely for the reason that if you enumerate rights, some people are going to say they're not written down. And if we knew this in 1787, surely we could know it now. And the history of the 20th century is the development of that idea, which is why I think, however imperfect, this was why I wanted to try to give you a sense of the 20th century as recognizing this. And this comes out of World War II in part because of the recognition of the notion of human right, which is what Douglas invokes here, is a worldwide development. So I understand that my colleagues who are originalists on this faculty, we have some premier originalists, don't necessarily think that Roe versus Wade should be overruled. And that is their position. You know, you can root it in the text, you can root it in other parts of the text, you can root it in privileges and immunities. But at the end of the day, when I wrote my piece in Slate criticizing the leaked opinion for going back to the 13th century, 1868, I mean, I wouldn't be sitting here if it was 1868. Amy Coney Barrett wouldn't be on the court in 1868 because we could not practice law. We were not covered by the 14th Amendment. It's only because of the judicial recognition of that during the 20th century that I sit here today. Now, it's possible to have a different originalist argument, but that's not the court. So that would be my answer to my originalist colleagues. Great, you've got arguments, but those arguments, such as the Privileges and Immunities Clause, perhaps that would bring a better world, right? But that was not used. I mean, it was not in any of these cases, you know, in the early cases. And so, however brilliant, you know, that may be as a solution to the originalist problems about women, this court hasn't invoked it. So my critique is of the court, not of originalism, in terms of their practice. My view is that it's selective, right? The textual, you know, I think they have misread the Second Amendment, for example. So over to others who have something to say.
I'd like to build on that, the selectivity of which we see throughout. You know, one can see that throughout a history of jurisprudence. One sees it quite deeply in this opinion. And I mentioned earlier that it does matter who gets to read the book, who gets to sit on the stage, right? So imagine if we think about the 13th Amendment in ways other than that kind of just it's bygone, it just freed slaves, right? As sort of this idea of it, and the 14th Amendment. And so what might that mean in terms of originalism and textualism? Like, what were they thinking? Well, the Library of Congress and libraries, my home library and office library, are filled with books where we understand what was happening during the period of slavery. We understand the sexual subordination that was taking place during that time. It was written about by abolitionists. It was spoken about when the 13th Amendment was being debated. And then if you think about the text of the 13th Amendment, neither slavery nor involuntary servitude shall exist within the United States, ... Well, this involuntary servitude is not one that is just simply being in the fields and picking cotton. It is an involuntary servitude that Black women had been subjected to as reproductive chattel in this United States. It's very clear. I mean, Thomas Jefferson kept his receipts. Mm-hmm. Right. So imagine if women were rethinking the 13th Amendment and saying, this is how we understand the 13th Amendment. It abolishes private and public entities from coercing involuntary servitude. To force someone to be pregnant for someone else's interest is involuntary servitude. Imagine if we look to the text of the 14th Amendment and how the 14th Amendment speaks very specifically in its very first sentence, all persons born or naturalized in the United States are citizens of the United States. Not the unborn, not fetuses, not embryos that are mentioned. What happens to be mentioned in the Constitution are those who are born. And so the selectivity, again, you know, one sees in this leaked draft opinion, but I'd also wish for us to imagine what happens when women are able to be the interpreters of our most cherished documents.
Can I follow up on that as well? Yeah, I think Michelle and Victoria are exactly right. we talk about, and I think a number of us have actually, without even intending to, have conceded this idea that the right to an abortion is somehow unenumerated and is atextual for some reason. And I think that's not the case. Michelle is exactly right. When they were drafting the Reconstruction Amendments, they were doing so with slavery top of mind, and they were very clearly and explicitly focused on repudiating not only slavery, but all of the indicia of enslavement that characterize the lives of the enslaved. And so my colleague at NYU, Peggy Cooper Davis, has written a marvelous book, Neglected Stories, The Constitution and Family Values, which goes into this and talks about how the 14th Amendment was supposed to address the conditions of slavery, the conditions of enslavement, the fact that there was no access to marriage, the fact that there was no family integrity and your children could be sold away from you, the fact that there was no bodily autonomy and you could be conscripted into sexual service for the financial betterment of your master. The Reconstruction Amendments were specifically aimed at repudiating all of those. And so when we concede that the right to abortion is not explicit in the Constitution's text, I think we give up too much. Like, there is an implication in that grant of liberty in the Due Process Clause. And the ratifiers and drafters of the 14th Amendment understood what they were doing, and they were consciously responding to the conditions on the ground, the conditions of enslavement.
Absolutely.
Do you have a quick follow-up?
Yeah. Do you think, like, methodologically, it was a mistake not to brief the case from an original's perspective? If this is a sort of 60 claim to the originals, I think those historical arguments would have been better received.
So the question was, do you think it was a mistake not to brief the case from an originalist perspective because a lot of the historical arguments were neglected, at least as we have seen from Alito's draft opinion?
I'll take a quick quibble at your 6. I think there are 3 self-proclaimed originalists, but 3 others in that conservative 6 mostly disavow it. So for tactical litigation reasons, I'm not sure originalist arguments would have been pitching at a workable majority. And, it's sort of on them, if you will, to join on whatever ground they want. We know, at least from this February leak, that 5 are where that draft indicates that they are. So unlike Bostock, a statutory case, for instance, where Chief Justice Roberts and Justice Gorsuch, with their textualism, I guess, Gorsuch, we know, Roberts, we only have the vote, join liberals to read Title VII in an expansive way. There's no sign of this originalism receptivity on the court. The academy scholarship, that is a different question, and the ferment will certainly continue, but that's not relevant to deciding the case.
And let me just mention something about that and why I believe he's correct, in the sense that I've been studying the court and calling the 6 Republican appointees as originalists and textualists because they call themselves that in public. But the truth of it, as a litigation person and someone who's worked as an appellate litigator, is that there are significant differences between their ability to focus on the original meaning and their consistency with that, as opposed to precedent. Okay, and that's why they've built up all these theories about precedent, because they know that originalism and textualism, their real assault is on precedent, right? Because if the text says it and your precedent doesn't, that's a problem, whether it's the meaning of the word legislature in the elections clause, right? That's to get rid of prior precedents. So that's why folks who are worried about precedent, like the chief, who's a prudential conservative, talks about history, appeals to it in his opinions, but isn't, as a litigator, a reliable vote in that direction. They're more pragmatist in their appeal to history as guidance, but not as determining the answer, as, say, Justice Thomas, who tries very hard to be as a more consistent originalist than even Justice Scalia, in my opinion.
Could I just jump in for 1 second? I was really struck by what Professor Goodwin and Professor Murray said, and I think the left needs a strategy, and I think Professor Murray is absolutely correct that we shouldn't concede that abortion is not an enumerated right. I think we need a textual strategy. I think Justice Kagan who we haven't mentioned yet, has famously said we're all textualists now. And I think that, a 13th Amendment argument building on Jones v. Alfred Mayer and the badges and incidents of slavery, a case that was authored ostensibly by Justice Stewart, but drafted by his law clerk, Lawrence Tribe, right? Would be one way to go. But I absolutely think, and I know Akil Amar and Jack Balkin and others have been on this, but Professor Goodwin's emphasis on the citizenship clause could not be more right. Right? That made everyone equal citizens. That's what Jacob Howard said in his floor speech introducing the 14th Amendment. This is the heart of the 14th Amendment. And we've lost sight of what the heart of that is. And there is no way that women can be equal citizens without control of their bodies. That seems to me an argument we have to make going forward and confront the majority with these textual provisions that it's ignoring.
Well, it was profound what took place. And we know the exercise of what was meant by this because we can look to history. It was not just Black men who were freed, right? If, in fact, as I mentioned in my congressional testimony a couple weeks ago, if this were meant that it only would apply to Black men, then we would have seen Black women stuck in the same position as they had been before and the prevailing laws continuing. But that is not what happened. So we can actually see the original meaning actually taking place afterwards and be able to see that. Clearly, the 13th and 14th Amendments were not intended only for Black men, I said then, in text, practice, or enforcement, and that legal history demonstrates Congress did not intend that Black women would remain in the confines of human slavery. But time and again, the judiciary has overlooked this text and its application to all women, especially Black women, on matters such as this.
I mean, go ahead.
No, I just wanted to throw in 1791. I agree with all of this, but at the start, the Fifth Amendment Due Process Clause, which, yes, was only for white men then, was a textual font for protecting their bodies and other fundamental rights. And the Civil War, post-war amendments spread that more widely. So that due process concept, the 14th Amendment due process, the 13th Amendment badges and incidents, the Privileges and Immunities Clause, equal citizenship, all of that takes something that was textually there for the chosen people at the beginning and constitutionalizes it for all.
Mm-hmm. But there's one other point that I'd like to add to. I know we have other questions, and that is within this context about stare decisis and selectivity. I think what we've seen is this kind of outcome determinative kind of jurisprudence coming from a particular wing of the court. Members of the court can be vulnerable to this generally, but I think that we've seen this particularly with the hostility towards reproductive health rights and justice. And one of the ways in which you can see Justice Alito kind of contradict himself is to look at Burwell v. Hobby Lobby. There is no precedent whatsoever. There is nothing in the Constitution whatsoever that you can find that grants religious identity to corporations. And yet we see Justice Alito in Burwell v. Hobby Lobby in 2014 go there. And so I think that when we sort of unpack this, we can be far more nuanced, in fact, than just looking at the record of these justices to be able to see that it's not just selective, it's outcome determinative kinds of jurisprudence. And that is really, I think, a threat to, more broadly, not just the context of reproductive health, but really a threat to our democracy and the rule of law.
Let me, before I want to hear more from my brilliant co-panelists, but I want to just read a few of the online questions so we can add their voices into the discussion, and they really build on some things that Professor Goodwin is saying. Is one of the questions is, isn't it true that the anti-abortion movement is primarily driven by religious beliefs? And isn't it true that Alito's focusing on personhood is primarily a religiously driven conclusion, not a legal or scientific one? Therefore, is there an argument against the Alito decision on the grounds that anti-abortionists seek to impose their religious views by law on others? I just have one other related question. Is there not a watertight judicial doctrine that one must only decide the case in front of them, on the facts in front of them? If so, does Justice Alito go beyond what needs to be decided in his draft of Dobbs v. Jackson? Obviously, Dobbs is on a lot of our listeners and people online's minds, and I just wanted to open this up more to my colleagues.
I'll really quickly say this, that there is deep concern right now about xenophobia, nationalism in our country. And on deeper inspection, there's deep concern about Christian nationalism on the rise in the United States. And this is being tracked, and that is really quite disconcerting. What we see in terms of this view, it is not even a full-scale Christian view. It's an isolated Christian view that is anti-abortion, certainly inconsistent with other religious ideologies of people in the United States. And I think that that's a very good point that's raised by that particular viewer.
The world would look very, very different if Griswold had been decided based on the fact that it was really largely an anti-contraceptive statute promoted by an element of the Catholic Church, because even Catholics are divided on this question. So our world would look very, very different. I just want to say something about textualism before maybe perhaps Professor Murray wants to talk about these questions as well. I'd be interested to hear. I think textual arguments have to be made, and I think originalist arguments are there. And I think what this case exposes is the selectivity, which Professor Goodwin and I have tried to point out. It seems simple. Text seems simple, but it's not in the hard cases. In the easy cases, of course, December 31 means December 31. I teach this all the time. 35 means 35, but that's not going to answer the hard cases. And one of the particularly annoying features of the current kind of textualism, as Professor Goodwin just demonstrated, is that it picks and chooses the texts it likes. It forgets the 9th Amendment. It forgets the 13th Amendment. It forgets some parts of the 14th Amendment. So it's to someone who spent a lot of years studying it, I find it disturbing in the sense of its opportunism. And that's why you see originalists coming to say, oh, well, Victoria, you're right, in terms of, this isn't really an originalist decision. This is living originalism, because there is text you could support. There is original history you could support. But that goes to a deeper problem, is why are we deciding cases? For 150 years, we never decided cases this way. For maybe 170. So this is why this methodology? Because in fact, what ends up happening in my latest study is that they end up looking at the consequences of their actions. And one of the galling things for many women, given the statistics that are, Professor Goodwin has noted, is the effects of this ruling, given the reliance that people have placed upon the right. So Professor Murray, I'd be interested in what you have to say.
No, I mean, I think that's incredibly astute. I do think, I don't know that I would use the term selective textualism or selective originalism more so than I think it is opportunistic. I think that's exactly right. And, let me try and thread these two things together and go back to the question about religion. Professor Goodwin's exactly right. There are plenty of faith traditions in the United States that do not have the same antipathy for abortion. In fact, you could think about, I was just at a thing for the National Constitution Center, and it was a panel on abortion and guns where, textualism and originalism might have come together with wildly different results. And, somebody noted that according to the court's interpretation of the Second Amendment in Heller, there was a right to self-defense that warranted very liberal access to a right to bear arms. And, I asked a question, like, what if we understood access to abortion under similar terms of self-defense? Because in fact, that is how the tradition of Judaism thinks about it. If the fetus poses a threat to the woman's health or even her life, then she is warranted in dealing with it by terminating a pregnancy. It is a mode of self-defense. You prioritize the mother ahead of the unborn child. And, I think I would hope we would see immediately after this decision in Dobbs challenges rooted in religious freedom, because one of the things we've seen in the last couple of years is that this is a court that very much prioritizes free exercise, perhaps to the detriment of the other part of the First Amendment, the Establishment Clause. And so, I think it would really kind of bring home the conflict if this court had to reconcile its antipathy for abortion rights with its exuberance for free exercise, because I think there is a complete clash there. And I would be interested to see how they resolve it. And indeed, if they resolved it by prioritizing the antipathy for abortion rights, I think we would understand that its understanding of even text-based rights is perhaps also similarly opportunistic.
I want to build on that self-defense concept just by flagging an incredibly powerful op-ed piece in the Washington Post this morning by Kate Manning, which is about the physical consequences of pregnancy and all the lasting health impacts. That's just empirical reality that only applies to women, pregnant, childbirth, and goes right to the self-defense argument. So putting those two together is an intellectual challenge that I think it is important to pose. If I understood the question correctly, I don't think speculating about the religious motivations of the justices is a productive enterprise. Everyone comes from somewhere and is a melange of their influences, learning, beliefs, and some of that may be religious or irreligious. And I just don't think there's a Establishment Clause doctrine against someone as a jurist proceeding with something in the mix that is religious that makes it an illegitimate decision. So I would push that to the side. I don't think that's helpful to the conversation. I think it is helpful when the justices show their work, and are candid about text or original public meaning or history more broadly understood, or you name it, as part of the path that leads them to the decision. That, to go back to where I started, that's why I like Jackson in his little compact concurrence, really sort of saying, here's where I am. This Supreme Court writes too much, but it would be very helpful if every justice wrote in small bites a little bit more and showed their work.
I just wanted to read one other historical question because we have some experts on this panel. The question is, can you discuss the fact that abortion treatments were widely advertised and accepted, even from the Sears Roebuck catalog, until doctors took over OBGYN? This was in the mid-20th century. So Alito's comment that abortion is a quote-unquote new issue is simply wrong. Even the Catholic Church permitted abortion until 1870, and Pope Pius IX.
Benjamin Franklin wrote about how to perform an abortion, right? So again, call it selective, opportunistic, both, in terms of what we've seen in terms of efforts to dismantle reproductive health rights. And also note, too, that within the context of so much of this, it really is important who gets to name what, right? Because eugenics gets misframed. Health and risks associated with pregnancy get misframed. I mean, if an average person were to sort of look at what happens and where the narrative goes, you think that having a pregnancy was the safest option that a person could possibly ever have, that abortions were alarmingly dangerous. And so it's hard for people to sit with that abortions are actually one of the safest procedures that you could possibly have. As Justice Breyer writes in Whole Woman's Health v. Hellerstedt, it's more dangerous to have a colonoscopy than it is to have an abortion. They're incredibly safe procedures, but the narratives that harmonize around this are completely inconsistent with that. The World Health Organization said that an abortion is as safe as a penicillin shot. So terrific that this point that's been made by the viewer here. But a couple other really quick points that I want to make, because we also misremember Roe v. Wade. It's a 7-2 opinion. 5 of those 7 justices are Republican appointed. Justice Blackmun, who authors the opinion, is put on the court by Richard Nixon. No one would dare say that Richard Nixon was far left, radical, lefty. Not at all. Prescott Bush, the father of George H.W. Bush, was the treasurer of Planned Parenthood. 1966, Dr. King receives from Planned Parenthood its Humanitarian of the Year award, and he writes a robust affirming speech about his pride in receiving this award and how important it is that women are allowed to family plan. And he uses the word cruel to describe when people are coerced into parenthood that they don't want. It's 1966.
Can I add to that, Michelle? To the extent that this new narrative about eugenics and reproductive rights is really intended, I think, to opportunistically exploit the Black community and racial
Race card.
justice. Yeah, and I think Justice Thomas knows exactly what he's doing. No one but him on the court could make this argument as forcefully as he does and as effectively. But what's missing from his entire discussion are actually voices from people in the Black community. It is true that this argument about racial genocide has been percolating in the Black community for some time, but it's actually been associated with sort of the most masculinist aspects of the Black community. So the Black Panthers talked about this. The Nation of Islam talked about the fact of government subsidization of family planning being part of a genocidal plot. Interestingly, Black women, both inside the Black Power movement and outside of it, were incredibly skeptical of this narrative. And Florence Kennedy, who served as a bridge between the women's liberation movement and the Black Power movement, noted for her Black brothers that, we want to be part of this movement. We want to be part of the Black Power movement. And if women are going to be part of it, maybe we need to travel light. Maybe we don't need to be the ones at home raising your children. And if you are really concerned about the question of genocide, she and other Black feminists said, you shouldn't be concerned about access to abortion or contraception. You should be concerned about what's happening in Mississippi, where Black women are literally being sterilized because they are dependent on the public fist.
Absolutely. And to just add to that, Melissa, I'm so glad that you mentioned that. On the night in which Dr. King was to receive that honor, I sometimes say he was off being arrested, and his wife, Coretta Scott King, who identified herself as a Black feminist, who delivered the speech and said that she couldn't have been more proud to be there that evening, reading his speech on his behalf, and also understanding just what the arguments were at that time in terms of the importance of Black women's autonomy with regard to their reproductive health.
I think we have time for one more question.
Anybody from the audience before I turn it over? Okay, so, one more audience question.
I'm really glad Professor Goodwin brought it up because it's not the most important issue probably, but I think it is worth talking more about. The stare decisis concerns that Alito's opinion brings up, I think, are quite demonstrable. And so if that does end up being the majority opinion, I'm just wondering if anybody on the panel wants to opine upon what stare decisis looks like going forward if this opinion is in fact the majority.
Well, as I said, I've been saying for years that the whole point of textualism and originalism, since it's a new method, right, is to reverse the Warren Court, right? The whole point is to be against precedent. And one of the things I'm trying to document is that they're doing this all over the place. It's not just in the high profile cases, but this will demonstrate it to the American public, in my view. I think it's going to be quite a blow. If you talk to young women, they are, my daughter, Mom, how can they do that? So it really is an important moment for the method. It's important for stare decisis, because one of the great things about stare decisis, if you care about the difference between law and politics, and even my student, I actually try to defend this because I've worked in the White House and in the Senate, and I believe in law and its importance, right? But it loses its value as law when it becomes opportunistic. There is no consistency, and the best way to maintain that is a consistency over generations, because it's like a case is like a vessel, and the opinions of people who had totally different norms, like from 1942, right? They're a signal of wisdom, right? I wrote my first article on the Federalist Papers, right? Some of the wisdom can be false. We can learn from it, but you look at it first, right? And it is a way to bind the whole country. This is why eliminating the 20th century is a huge mistake. It's a huge mistake. Whatever you think about the Warren Court, there's a lot more to the 20th century that we learned in constitutional law. Some of it errors, some of it, Faulkner. Some of it actually wisdom that now everybody embraces. So I think stare decisis will, they have a standard according to Justice Barrett. We do our standard. I think that the standard is easily manipulable, and I am not convinced that it too would not be used opportunistically, and that this is why this case has taken on not only an importance about abortion, but about law itself.
Mm-hmm.
Yeah, I agree with that. And I just want to flag Justice Thomas's recent comment in his conversation with John Yoo. Justice Thomas said, stare decisis means you've got no argument. And in fact, stare decisis begins by making a very clear argument. We stand here, which is on the path of history. I think Cardozo said something about the power of the beaten path. It may not be the right path, but it came from somewhere, it developed for certain reasons, and it's commendably rational to begin by noting where one stands. I think that is the stare decisis virtue and argument.
You know, let's be clear, and I completely agree with my co-panelists here, that there are important reasons and occasions for overturning unjust laws and prior judicial rulings, right? We saw that with Brown v. Board of Education. And when you look at the myriad laws that were recorded by Polly Murray in her book, Race Laws, which Justice Thurgood Marshall called the Bible of the Civil Rights Movement, right? Like thousands of just the most ridiculous laws that kept Black people in second class, third class, fourth class citizenship in the United States. You know, ridiculous. You can't play checkers in the park. I mean, all of that, right? Dismantling that, very important. But to another aspect of your question, I'm concerned about what this means when what may come from the majority of the court saying, well, we'll just take this to the states, and the dog whistle that means when it's been this very Supreme Court that's dismantled key provisions of the Voting Rights Act, which has made it very difficult for Black people to be able to exercise the right to vote, very difficult for Black women who are affected by this. You know, in the state of Mississippi, 118 times more likely to die by carrying a pregnancy to term than not. And for the court to say, well, just take it to the polls, when we, in fact, you live in a state where historically Black women had to guess how many bubbles on a bar of soap to vote, how many jelly beans in a jar, to take it back there, a state that was all too happy in its addiction to slavery, Jim Crow, and now voter disenfranchisement. It's hard to see that in any light other than what it represents, a level of kind of cruelty. And so the pernicious aspect of what I think is to come is the fact that states can go rogue. And we've already seen that. Texas has a law that is inconsistent with Roe v. Wade. Roe v. Wade is still the law of the land. Oklahoma's just passed a law saying birth begins at conception. Well, that's inconsistent, and banning pregnancy, banning abortion, well, that's inconsistent with Roe v. Wade, right? And so this is what's alarming, what comes next, this kind of next wave of not what is Jim Crow, but this intersection of Jim and Jane Crow, these kinds of laws in this new era.
I think we're over our time here, and we need to wrap it up. I wanted to thank personally all of my fellow panelists, Professor Victoria Nourse, Professor John Barrett, Professor Melissa Murray.
That's okay. My friends.
I'm totally Michelle Goodwin. I'm sorry, I'm blanking.
It happens to the best of us.
Thank you so much. You've come from near and far to be with us, and you've enlightened us on the Dobbs opinion and on history. And thank you very much for being here in the audience and for being online.
Thank you.
Thanks, everybody.
Bye, Melissa.
Good seeing you, Melissa. Good being with you.
See you all. Bye, John. Bye, Victoria. Bye.